The next matter is the Pennsylvania Environmental Defense Foundation versus the Commonwealth of Pennsylvania and the Governor of Pennsylvania. Representing the Environmental Defense Foundation is John E. Child. Representing the Commonwealth is Abigail Junta.
Excuse me, good afternoon. The Pennsylvania Constitution guarantees Pennsylvanians the right to clean air, pure water, and the preservation of state lands. In this case, an environmental group asked the court to determine whether the right to preservation is violated when state lands are leased for oil and gas extraction, and the lease revenue is used to supplement the state's general budget. Mr. Child.
I'm sorry, Your Honor, did you want me to proceed?
Yeah, I'm sorry. Yeah, you may proceed. Thank you.
Yes, Your Honor. May it please the court. The issues before the court today are based on a remand from this court from its decision for June 2017, requesting the court of the Commonwealth Court to make certain determinations regarding other forms of income from oil and gas extraction on state lands, including bonus and rental payments. In this court's remand to the Commonwealth Court, you instructed the court that the proper standard of review of Article 1, Section 27 is the text of the amendment itself, as well as the underlying principles of trust law. The text of Article 1, Section 27 does not support the Commonwealth Court's findings that the beneficiaries of the trusts are divided into today's generation, who are life tenants or life beneficiaries, and future generations who are remainderment. The Commonwealth Court found that they had to make that distinction in order to be able to apply Section 9 of the 1947 Principles and Income Act. The text of Section 27 does not support the Commonwealth Court's reliance on Section 9 of the Principles and Income Act. That act applies to trusts whose purpose is to provide income to beneficiaries who are life tenants. The beneficiaries of Section 27 are not life tenants and are not entitled to income from the conversion of public resources. The text of Section 27 does not support the Commonwealth Court's argument that the Conservation of Natural Resources Act defines the constitutional authority of the respondents to lease and sell public natural resources. Under the Conservation of Natural Resources Act, the rights to lease are limited by the constitutional protections of Article 1, Section 27, not the other way around. If there's a conflict between the respondent's duties as trustee and their statutory responsibilities, the constitutional duties must prevail. Nor does the text of Section 27 support the Commonwealth's assumption that because the drafters changed the wording of the amendment from preserve to conserve, drafters did not intend to prevent the Commonwealth's ability to utilize the resources. The 1970 Legislative Journal explained the change, citing the concern of Maurice Goddard, then Secretary of DCNR. He believed the courts might misinterpret the word preserve when applying it to replenishable resources, such as cutting trees, catching fish, or hunting game, and that the word preserve would prevent those kinds of activities. The Legislative Journal then went on to explicitly state, substituting the words conserve does not radically change or weaken the meaning of the amendment. If the Commonwealth is allowed to sell the public natural resources for revenue, then a radical change to the purpose of the trust weakens the ability to conserve and maintain those resources. The underlying principles of law aren't just any trust principles. They are those principles that apply to and support the meaning of the constitutional trust. This court laid out those underlying principles in a 2017 opinion, including, as trustee, the Commonwealth is fiduciary, obligated to comply with the terms of the trust. The explicit terms of the trust require the government to conserve and maintain the corpus of the trust. As fiduciary, the Commonwealth has the duty to act towards the corpus of the trust with prudence, loyalty, and impartiality. This court asked the Commonwealth Court to determine what the true purpose of the leases for the oil and gas that were subject to the previous litigation. The terms of the leases are specific and clear. For the sole purpose to allow exploring, drilling, operating, producing, and removing the oil and gas, and to lay pipelines, construct roads, tanks, towers, and structures to produce, save, take care of, and transport extracted products. That goes far beyond the Commonwealth Court finding that the purpose of the lease was solely for the exploration of gas. The payment of the bonus and rental payments were for all of those activities cited in the lease, not just for exploration. The payment.
Counsel, Justice Barrett, can I interrupt you? Because you're getting deep into your argument, and I think everyone was giving you the courtesy of getting your statement in, but not to complete it. So, just preliminarily, it's not especially easy to apply trust law concepts to Article 1, Section 27. And I appreciate that the drafters said as trustee of these resources, which is where it comes from. But what's wrong with the Commonwealth Courts struggling with all the people, including generations yet to come, and concluding that people who are lives in being are have life estate in these assets, and people who are the lives yet to come, the lives that will come subsequently, are remaindermen. It struck me as a creative way to put perhaps to put a square peg in a round hole, or to round out the peg, if you will.
Well, first, Your Honor, there's the factual problem. Who are the people who are entitled to can be considered life beneficiaries? Are they the people who are just born today? Are they the people who are elderly, like myself? Are they people who are never use the resources? It's very hard to discriminate who those people are and what their source of the income would be. I'd like to address from a legal standpoint, if I might, that to be able to, for a statute like the 1947 Principles and Income Act to define what the meaning of the Constitution is, would take away control of that Constitution from the people and give it to the legislature. So I believe it's wrong to rely on a statute to define the meaning of the Constitution.
So respectfully,
John, in that vein, if you set aside the rubric, if you can, and sometimes the analysis is inextricably bound up with the result, but if you put aside the trust analogies and the notion of life tenants and remaindermen, is the result supportable, separate from the analysis?
To make the division between income beneficiaries and remaindermen?
No, to take the money and put it in the general fund of the Commonwealth.
Well, certainly that's without any authority under the Constitution, and it goes beyond the findings of this court that you cannot convert a public natural resource to income and use it for non-trust fund purposes. Beyond that, I mean, the very basic concept of what the authority the trustee has under any trust, much less a constitutional trust, is limited by the terms of that trust. He cannot go beyond the purposes to conserve and maintain the public natural resources, and to divide the resources into, to convert the resources first of all, and then to divide it into income for some unable to be identified persons living today and future remaindermen is without any authority under the Constitution.
Councilor Justice, if I just might follow up on that. The Commonwealth Court decided, they interpreted the Constitution to create life tenants and remainder men without any analysis of the text of the Constitution itself. And my reading of the Commonwealth Court opinion, and granted, they were dealing with, or they either were dealing with a complicated subject matter or they complicated the subject matter, but it appears that they defined remainder men and life tenants because of the Principal and Income Act, which used that predicate for distribution of certain monies in the terms of oil and gas leases. So, two things. I see the Commonwealth Court's holding as to oil and gas leases, the Pennsylvania Constitution creates life tenants and remainder men. Am I correct in that? As opposed to, they weren't interested necessarily in what the Pennsylvania Constitution meant. They were interested in what it conveniently meant in terms of a statute that they had before.
I think that's very clear from their opinion, Your Honor. They specifically state and acknowledge that the reason why they've made this assumption of the two types of beneficiaries is so that they might apply the delineation under the 1947 Principles and Income Act. Without that understanding, without there being this assumption that the trust authorizes there to be income beneficiaries, therefore you can assume if that's the case, that they must be able to receive income, then you can apply the Principles and Income Act.
So where does that leave us under the, and truly, I'm not being critical of the Commonwealth Court because they wrote a very detailed opinion, but it seems that they worked backwards from authority that was easy to follow and then decided that that's how the Constitution was interpreted. And, you know, I understand why they did it, but I think the bigger question is, how does this concept of life tenants and remainder men in terms of beneficiaries work in the broader scheme of Article 1, Section 27? What about, let's just assume for the sake of discussion that the Liberty Bell is at issue as a natural resource of the Commonwealth, and it includes aesthetic values and things of that nature. How do you look at the Liberty Bell and say there are life tenants and there are remainder men? How do you look at all of the natural resources that the Environmental Rights Amendment encompasses and apply this limited definition that the Commonwealth Court explicitly only used to define those interests in terms of oil and gas leases?
Yes, Your Honor. I can't explain how they would do that under that concept of dividing the beneficiaries up. And yes, they did not apply the very basic tenet that this court requested them to apply, instructed them to apply, that the proper standard of review is the text of the amendment itself. They never went to that text to see what justification there would be for these decisions.
Well, more precisely, the Commonwealth Court did two things that were really contrary to the majority opinion in the case that they were handling on remand. Number one, we refer to all of the people, including future generations, as co-owners. We specifically did not differentiate between, you know, life tenants and, but more importantly, we specifically held that unquestionably royalties are part of the corpus. The Commonwealth Court, applying the act that it worked backwards from, gave a third of the royalties back to the trustee as income. So the clues from PEDF 1 was that we viewed them as co-owners, and secondly, royalties were to go back into the corpus, were both not followed by the Commonwealth Court on remand.
Well, Your Honor, the amendment itself specifically states that the public natural resources are the common property of all the people, including future generations. So there's absolutely no question about that. And the Commonwealth Court did not examine that portion of the amendment to make its determination as to how they would divide these, the beneficiaries' interests.
Let me just bring this to conclusion, then I'm really done. If the Commonwealth Court is incorrect in its interpretation of Article 1, Section 27, then the rest of the opinion falls by the wayside.
It would have to, Your Honor.
Okay, that's all. Thank you.
Mr. Child, perhaps I wasn't very articulate with my question, and I don't want to dominate the argument, but the chief executive of the Commonwealth and the chief law enforcement officer, the chief legal officer say this: unlike royalty payments, which are tied directly to the extraction of oil and gas from state forests and are compensation for the severance of that asset from the Section 27 trust, excuse me, bonus bid payments and rental payments are made purely to secure the lease and for the leasee's ability to explore and develop the property in anticipation of extraction. They are therefore not proceeds received in consideration for severance of a trust asset and are income that need not remain in the trust corpus.
Yes, Your Honor. They did that.
How do you respond to that assertion?
Well, they didn't comply with this court's request to look at the true purpose of these bonus and rental payments under the lease itself. The lease is very explicit to state that the bonus and rental payments, first of all, are to be able to go onto the Commonwealth land to do all of the activities that are specifically identified in the lease. If you'd like, I can read those activities to you. For the sole purpose to allow exploring, drilling, operating, producing, and removing the oil and gas, and to lay pipelines, construct roads, tanks, towers, and structures to produce, save, take care of, and transport the extracted products. That goes far beyond the limitations that the Commonwealth Court applied to their concept of what this money was for. That money was paid at the time that money was paid. The leasing had the authority to go onto the property and do all of those activities that are listed in the lease, including transporting, extracting, and severing the oil and gas from the public natural resources.
Can I follow up the chief's question? I'm sorry, Justice Donahue, do you have something?
This is a really a very precise question. As I understand the Commonwealth Court opinion, correct me if I'm wrong, those bonus payments are used as a set-off against royalties that are actually earned. Or maybe it's the other way around. I mean, once a well starts producing, the oil and gas company gets credit for some portion of the bonus payments that they have made.
I don't believe there's any credit for the bonus payments, Your Honor. The bonus payment is for the specific right to get the lease and for the first year of that lease in its development. Then it goes to the rental payments provisions that continue until there's actually extraction and purchase of the oil and gas. The purchase, once that purchase is made, no further rental payments for that part of the lease agreement are required. So the bonus payment is an initial payment to get the lease, and for the first year of the lease, it's as the former Secretary of the DCNR stated, the purpose of the bonus is for the lease requesters to be able to project what they think is the value of the oil and gas on that lease, and that's the basis of their bonus payments.
But Mr. Childs, Justice Baer, in furtherance of Justice Donahue and the Chief's questions, there is a really obvious distinction. The Commonwealth keeps the bonuses and the rents, even if the gas companies don't get any quid pro quo, even if there's no gas. So that's uncontested. Is that correct?
That is correct.
Okay. On that basis, applying private trust principles, and I honor stare decisis. I thought this should be deemed public trust principles, but the majority of the court said private trust principles. Applying private trust principles, the corpus of the trust, if you will, is depleted by the loss of gas and is compensated by the receipt of the royalty from the loss of gas. The corpus is not depleted at all through the payment, and I acknowledge you with the underlying purposes. These aren't charities. They want to come explore for gas, but the corpus is not depleted at all. In fact, maybe it is enriched through the payment of bonuses and rents. So explain to me again, even though I understand the purpose, why that, as a matter of private trust principles, that's not distinguishable from the dissipation of the natural resource.
Well, Your Honor, the fact that they are willing to pay what they believe is the amount of oil and gas that they can extract determines why they made the payment of the bonus and rental payment. In order to find that, they needed to get onto the property and have the right to look for it, explore it, extract it. Now, the fact that they chose not to do that does not change the purpose of them paying that money. The purpose
if I can interrupt, they certainly do that. They just come up with a dry well, I think. I think wasn't there evidence that there were 16 dry wells that paid the Commonwealth $150 million, and nobody lost anything from the natural resource?
That's correct, Your Honor, and that doesn't support the understanding that not returning the money authorizes them some more limited basis for the purpose of the lease. How do you determine what the limits of the lease are? Different future actions of the leaseholder, that he did or did not do something. He made the payments. The payments immediately went into the oil and gas lease fund. For the purposes of that lease fund, they were immediately available to do all the things that were required under the lease fund before it was ended by the legislature. And if, for instance, DCNR had taken that money and used it for some purposes the day after they got the lease, would they be required to return that money to the leaseholder when he said, I've changed my mind, I don't want to further explore for oil and gas? I don't think so.
Well, I think respectfully, the point for the... Go ahead and finish. I'm sorry. No, you go ahead and finish.
The contract was completed at the time of the exchange of the money with the right to have the lease. And the terms were defined from that moment on. They aren't changed by some subsequent actions of the parties.
My last question, because I also don't want to dominate this, but I thought the Commonwealth Court's opinion was somewhat persuasive. I went back and read the majority opinion, and it from our court, and we said clearly, apply private trust principles with, and I don't have the quote in front of me, but with fidelity. And I think the Commonwealth Court tried to do that. Now, maybe they went awry with the life beneficiaries and remaindermen, but I'm not sure, maybe I'm asking the same question, and maybe you've answered it, and I'm sorry, how they went awry distinguishing between the trust corpus and the lack of impact on the trust corpus. I guess you've answered that question for me, haven't you?
If I have, I would like to add to that, Your Honor. If the Commonwealth Court is able to say, well, we're going to choose some trust principle. Let's say it has no bearing on income or other reasons, but it doesn't really deal with the purposes of the constitutional trust. That would allow them the authority to change the meaning of the trust by the very nature of their arbitrary choice of trust principles. The trust principles have to relate directly to the purposes and the corpus purposes of the trust in question. You just can't arbitrarily select some other trust principle and say, well, let's work this into how that can apply to our constitutional trust. As is obvious from applying the terms of the Income and Principles Act, they change the meaning of the Constitution by doing that. They can't apply a trust principle that changes the meaning of the trust. If that helps you at all, yeah.
It does, and I thank you.
Okay, well, you've well stated your case and as an advocate for your client. We'll hear now from the Commonwealth.
Represent Governor Wolf and the Commonwealth in this matter. Justices, this court's direction to the Commonwealth Court was to determine the true purpose of rental and bonus payments. The true purpose is the exploration, drilling, and access to state forest lands. The Commonwealth Court's holding in that sense is correct. They are therefore income rather than trust principle, and it's unlike royalty payments that this court held are for the removal, the disposition or dispossession of a trust asset. Those are therefore principle. Here, with rental and bonus payments, there's no severance of a trust asset related to those rentals. There are several types of consideration paid involved in the leases issued by the department. Bonus, bid payments, rental payments, royalties, and of course, the taxes owed on late payments. But they really fall into two buckets. The rent payments are these bonus bid and rental payments. The rental and royalty payments are paid at completely different times throughout the lease. Initially, the lessees pay their bonus and rental payments to obtain access to explore the state forest lands. As opposing counsel indicated, they're for exploration and access to those lands. Those payments are then reduced or fully stopped when the well starts producing and natural gas, the natural resource, is extracted and removed from the trust. Royalty payments then kick in. They're specifically paid in exchange for the removal of the trust asset. At that point, there's a change in possession and physical possession of the natural resource. On the other hand, the rental payments, which include the bonus bid payments, are paid for just the exploration and access. They're made regardless.
Justice Baer, I have two sort of quick questions. The first one's just to see if I misread the Commonwealth Court's opinion. Did it, in fact, disobey I shouldn't say disobey, disregard our holding in the case that remanded it regarding royalty payments, and in fact take one third of the royalty payments and move it to the general fund as an ultimate conclusion?
Thank you for that question, Justice Baer. No, I don't believe that the Commonwealth Court did that. Royalty payments remain principal and body, corpus body. They must remain within the trust and be used for conservation and trust purposes. The Commonwealth Court was dealing with these different rental side of payments when it discussed the Principal and Income Act and the division of 1/3 and 2/3 with those payments.
Well, it appears that I always speak for myself, that I was perhaps wrong because I didn't dissent from the royalty payment, and under the Principal and Income Act, if you buy that analysis, the royalty payment would be in it. But again, that's the law of the case, that's stare decisis, and I thought the Commonwealth Court honored it, so I appreciate that. Let me ask you a second question. Is the distinction that you're drawing between royalty payments for dissipation of gas, going to the corpus of the trust as a quid pro quo for dissipation of a natural resource, and rent and royalty being divided in accordance with the Principal and Income Act as not going for dissipation of the natural resource. Is that distinction dependent upon the life tenant remainderment analysis, which was the first half of the Commonwealth Court opinion, or does it stand regardless?
I believe that it stands regardless, Your Honor. I don't think that it matters whether we're necessarily dealing with life tenants and remainderment or otherwise. That distinction must be made regardless.
Counsel, if I may follow up,
Sure.
my understanding is that the Commonwealth Court did in fact indicate that a third of the royalties go to the trustee in this context, but I mean, we can determine that. But the entirety of the Commonwealth's opinion is based upon its usage of the Principal and Interest Act. I don't know how you sever that analysis and indicate definitively that you would come to the same conclusion. I mean, it's based upon a place filler, so to speak, when there's a lack of clarity in the trust document. And I don't believe the Commonwealth ever took the position that the Principal and Interest Act applied in this context. My understanding is that your position before the Commonwealth Court was you get everything. And PEDF's argument was, no, we get everything. And it was the Commonwealth Court who devised this notion based upon its interpretation of the Pennsylvania Constitution as creating remaindermen and trustees that fit, remaindermen and life tenants that fit very nicely into the statutory scheme that they wanted to rely on.
Your Honor, you're correct. But this court in PEDF 2 specifically directed the Commonwealth Court to determine the appropriate categorization of these payments under the trust law that was in effect at the time that the ERA was enacted. The ERA was enacted in 1971, and the trust law in place then was the Principal and Income Act of 1947.
But that's only if the trust document created remaindermen and life tenants. I mean, if you have a trust document that does not do that, if you have a trust document that says, treat all of the people the same, which is, I believe, what our Constitution says, you don't have classifications of beneficiaries. You have one class of beneficiaries whose rights must be protected in precisely the same way in every activity that the trustee takes. I mean, it's just it's a totally divergent view of what Article 1, Section 27 says. And my question I'll ask to you is what I asked to your opposing counsel. Does the Commonwealth Court's adoption of this notion of life tenants and remaindermen, i.e. classes of beneficiaries to fit the mold of the Principal and Interest Act, fit with every other common natural resource in the Commonwealth of Pennsylvania? Because there's nothing in the Constitution that would suggest that different resources are treated differently as to who the beneficiaries are.
Your Honor, I believe that it would treat them the same. I'm thinking through the different natural resources, flora, fauna, scenic mountains, etc. I believe that this treats all of those natural resources the same, and when they are leased by the Commonwealth or by the Department of Conservation and Natural Resources, the lease then has to divide out those payments, and here they did. And those payments are different and have different uses under common law trust principles.
Can I ask a follow-up question on that, which also goes to our holding in PEDF1? We indicated that leases couldn't be structured so as to, I'll use different language, shortchange the beneficiaries, i.e. all the people. And I know this has to, so there's an accounting to take place and things of that nature, but it appears from what I can see here that given the magnitude of the upfront payments, in almost every circumstance, the trustee gets more of a monetary benefit than all of the people.
Well, Your Honor, it certainly depends. The royalties are based upon the fair market value of the resource that's being removed from the trust. And the Principal and Income Act of 1947, its use in this case, as determined by the Commonwealth Court, now would allow only 1/3 of the bonus bid and rental payments to go to those.
Forget about the Principal and Income Act, just for the purpose of my questioning. I'm not sold on it, but others of my colleagues may be, that we could parse it that way. But in the case we have before us, the magnitude of the dollars was always in the upfront payments. And you know, the entire purpose of the trustee's responsibilities in exercising, you know, the fiduciary duties that go along with it is to not benefit to that much, well, to any extent of that magnitude than the people, you know, whose trust property is to be conserved and maintained. So assume the Commonwealth Court is right, or assume that we conclude that, you know, they say what they say. Suppose we buy the notion that lease companies can build roads and construct roads and take down trees in order to construct them, you know, as part of the exploration rights. And okay, that goes into the bonus payment. Does that not result in a lopsided distribution of the funds that are generated, and therefore a breach of the fiduciary duty of the trustee to not use those funds for the conservation and maintenance of the Commonwealth's natural resources?
Well, Your Honor, the appropriateness of the charges for either bonus bid payments, rentals, or the royalty payments has never been raised in this matter. I believe in footnote 25 of this court's 2017 opinion, it was indicated that the leases, the question's never been raised and is not before the court. But to Your Honor's point, the trustee must act with its fiduciary duty to the trust. So they must act with loyalty, impartiality, and prudence. If for some reason they did not, then there would be, you know, obviously a breach of that responsibility.
Okay, I guess I'm always sort of get back to the historical situation when the Environmental Rights Act was adopted. At that point in time, any money that was generated by use of the forests and the land in the Commonwealth and the natural resources went right back into the Environmental Lease Fund. It wasn't until it was real money and the legislature decided that's too much for conservation, did this notion come into being that all of that money did not go back into the lease fund. So the background we have when the trust was created, that the funds that were being generated went to conserve and maintain the natural resources of the Commonwealth. So, you know, we've sort of come 180 degrees from that to a situation where now the leases could generate more funds for the trustee than they do for all of the people. And, you know, that's why I'm sort of probing this notion of what is the fiduciary obligation in this sense? Do you use as much as you can in order to conserve and maintain the resources or not?
Well, pursuant to the Environmental Rights Amendment, the Commonwealth must conserve and maintain. Now, that's not a full ban on the use of the Commonwealth's natural resources, but it is the trustee's obligation to conserve and maintain those resources. And
Could
they
I
do
jump in
so.
with a question? Could I get a question in here?
Yeah.
What is should your client prevail? What is to prevent the executive branch from negotiating these leases so as to front load the bonuses and to the detriment of the royalties on the back end?
Well, again, Your Honor, that involves information that is not in the record at this time, and it has not been raised. But obviously, their fiduciary obligations prevent that. They must act with loyalty, impartiality, and prudence in the drafting of the leases. And they are negotiated with the lessor and the lessee. It would be a breach of their trustee obligations.
Counsel, Justice Bear, I have just one more question, I think. And I find this a difficult case. I see both sides of it. In looking at the Principal and Income Act, and presuming arguendo that it's applicable, it does not discuss life tenants or remainderment. However, it does say that monies, proceeds received as rent, and I think bonuses, and it does say royalties there, but forget that for a second. 2/3 shall be deemed principal to be invested to produce income. The other 1/3 will be, let's see. Yeah, if received as rent, payment of lease or royalties shall be deemed income, and that's 1/3. And the remaining 2/3 shall be invested as principal to produce income. How do you support the Commonwealth Court where the 1/3 of all these proceeds is income and the other 2/3 principal to be invested as income, get from there to the idea that the people under the Equal Rights Amendment don't get 100% of the money? Because the statute doesn't seem to distinguish between income and principal to be invested to produce income. Do you follow what I'm saying? I'm thinking out loud.
Yeah, I do believe I understand, Your Honor. And to your point, why don't they get 100%? And I think it has to go back to the fact that, at the moment that the bonus bids, we were talking about what would happen and what if they front loaded. Those bonus bid payments at that time are wholly unrelated to any piece of the natural resources being removed from the trust. The trust itself still remains the same. So if we move forward into the Principal and Income Act of 1947 and it's divvied up, that 1/3 can be used as income and 2/3 remains in the trust, we're still talking about the portion that must be recouped is the portion of that pie of the trust that has to be removed, or that has been removed and must be then replaced, whether it's by money or other land or some form, to keep the trust whole. That's the trustee's obligation. I think perhaps that answered Your Honor's question.
I think it's the best you got. It'll cause me some sleepless nights, but I appreciate it.
Just one more question. Under the Principal and Incomes Act, with the income going to the trustee, isn't that with the assumption that inures to the benefit of the life tenants?
That the income benefits, yes.
And see, isn't that the problem? That's the difficulty with distinguishing all the people and putting them into categories of life tenants and remainderment. Because here, it is not the trustee's intention to use that money for the benefit of all the people in the context of Section 27 of our Constitution. It is the trustee's intention to take that money out of the trust and put it into the general fund.
It was That was what was done in 1604E and 1605E of the fiscal code.
But that is what they intend to do. I mean, I'm not saying it's bad or wrong. I'm just asking if that's at all consistent with Article 1, Section 27. I mean, there's no intention of the trustee using the income to maintain and conserve the resources for life tenants. Their intention is and will be to take that money and put it into the general fund.
I think you have to go back to whether or not a natural resource is actually the root of the money. And that is the separation between the rent payments and the royalty payments. The natural resource is what has to be conserved and maintained. That money is the important part, that part of the estate is the corpus of the trust. But we're also talking about a whole other bucket of payments that if that is utilized by the general fund, that would not be in violation of the ERA.
Except it's in violation of the fiduciary duties, because under the Commonwealth's holding, all of the people maintain is 2/3 of the royalties. And the Commonwealth as trustee, for use outside of the benefit of all of the people in the natural resources conservation and maintenance, gets the vast bulk of the proceeds.
The Principal and Income Act actually takes care of that, and the vast proceeds, the 2/3 of both, if we're reading it as Your Honor and Justice Baer did, that it's 2/3 of both royalties and rentals remain as corpus of the trust, then only 1/3.
But not the upfront money, which is where all the big money is.
The big money, as you refer to, the bonus bid payment, is part of the rent and would be only 1/3 income. 2/3 would have to remain with the corpus of the trust.
Only part of the rent if you bind yourself to the terms of the lease, which is between the Commonwealth and some gas company. Not if you look at it in terms of Article 1, Section 27.
Your Honor, I respectfully disagree. The terms of Section 27 are in reference to the natural resource being removed. It has to be maintained. If it is removed from that pie of the trust, the money that is put in to recoup is what the Environmental Rights Amendment is concerned with. The bonus bid payments have nothing to do with the removal of an asset from the trust.
So Ms. Gunta, just so that your point is clear, and Justice Donoghue disagrees with you, and we'll straighten this out in due course. It's what we do. We don't decide everything unanimously. It's your position that under the Commonwealth Court's decision, the trust fund here, whatever it's called, the successor to the Oil and Gas Act, gets 100% of the royalties and 2/3 of the bonuses and rents. Is that accurate?
Yes, Your Honor.
You sure?
Yes, that was my understanding of the Commonwealth Court's decision. Yes, and we do support that and would ask that the court affirm.
Thank you.
Thank you.
Thanks to both.
Thank
counsel.
you.
That concludes our argument list for today. So the court will now recess.